can we please discuss the municipality's responsibility in instances where an eviction might lead to homelessness? Can the court order that an eviction not be granted on the basis that the municipality has failed to find alternate accommodation for illegal occupants? And where does this leave the homeowner or owners in general? Cilna?
So we actually have quite a lot of case law on this, high court case law, like constitutional court case law. And actually now we miss our good friend Greg Vermaak on Blue Moonlight Properties and all the famous cases that we use where he was attorney of record. But Greg, so I'll answer this one on your behalf. But there is a municipality, there is an obligation, a constitutional obligation on the municipality to provide alternative accommodation. Catch is the person that is claiming to be homeless and destitute after an eviction will actually have to be homeless and destitute. I mean, we obviously do only evictions, so we see a lot of evictions. And I've seen like easy evictions, and we always call your rental evictions, your tenant that didn't pay rent, where you have to place on terms and cancel. We call those easy evictions because they are pretty easy. It's clear, straightforward, nothing funny law. So on an easy eviction like that, if you had a rental that you pay 25,000 Rand a month rental, we commence the eviction, the respondent files an answering affidavit, and they say, oh, but wait, I'm going to be left homeless and destitute. We all just like, no, in fact, you will not. If you were able to afford and qualify for a 25,000 Rand a month rental, unless something miraculously very strange happened in your life, the chances of you being left homeless and destitute is slim to none. But the court has an obligation in terms of the provisions of the Prevention of Illegal Evictions Act to do an inquiry into this. So what we see is the moment the court has a concern about the respondents potentially being left homeless and destitute, the court will order that the municipality engage with the respondents, the illegal occupants, and then provide the court with a report to say what is happening in this. Now, if done correctly, you can actually end up with a dismissal of an eviction. And what I'm saying if done incorrectly is, if, for instance, the municipality isn't added as a respondent to your eviction proceedings, the court has nothing to fall back on. So let's say you go to an attorney that doesn't do evictions for a living. They don't know that they need to add the respondent, the municipality as a potential respondent, and seek potential relief against the respondent. You could end up with a dismissal. That is true. But I'm not saying that you can get a dismissal based on law. That's basically a procedural dismissal, more than a true legal position, because legally, constitutionally, and in terms of by, the municipality has the obligation to provide alternative accommodation to a homeless and destitute person. And like I said, that was confirmed in multiple cases. So in a situation where you do an eviction, every single eviction, I always recommend to the attorneys I train, and obviously Bruno, I know you do this, we all do this, because, you know, every single eviction expert attorney will do this. You add the municipality as a respondent to your proceedings. And if you then have a problem, because you can't necessarily foresee this, say, for instance, my example that I used on a 25,000 Rand a month rental, say in the meantime, that income was derived from one of the spouses, they got divorced, the spouse that's now remaining in the property really does not have an income, bad things happened mid-divorce, somebody passed away, and really this person will now be left homeless and destitute. There is an obligation on the municipality to do an inquiry and provide alternative accommodation. I need to make it very clear, guys, when we talk about municipal alternative accommodation, we're not talking a nice RDP house. We are talking emergency alternative accommodation, which is very often tents. So those army sort of vibe tents, or like a communal living situation. We're not talking luxury living here at all. So if you're on the other side of the situation and you won't actually be left homeless and destitute, but you hear the term alternative accommodation provided by the municipality, be aware of the fact that it's not something pleasant. It's really it's basically just short of living on the street still. So that's important to be aware of. But as the homeowner, you will never, ever, ever be in a situation where you have to provide another property for anybody. Even if somebody's been in occupation, illegal occupation, for a period of longer than 6 months, then the Act does say that you might be responsible to provide alternative accommodation. But how the courts practically apply that is the court will simply allow the respondent extra time to remain in occupation of the property he is already in. So as a landlord, never ever be worried about, or a landowner, never be worried about a situation where the court will never order that you buy a flat for somebody or something like that. And as property owners, make sure you get to the right attorneys to do the evictions. Specialist attorneys won't accidentally be caught in a situation where you don't add the municipality. And you can request an order. Say, for instance, you can already see, here's a situation and somebody's going to be left homeless and destitute. We know exactly how to handle it. You bring an extra application to compel the municipality to provide a report, which saves a lot of time. If you sort of wait and hope for the best, it could be a 2-year game, but in real life, it wouldn't delay your eviction with much more than a month.